be muted and remove themselves except for myself, Mandy, and Rebecca, okay?
So how do I remove myself?
No, well, you can stick with audio, just and mute, but close the video. Thank you.
Stop the video. Okay.
All right, we're getting there.
Am I in?
And this should give us enough bandwidth to have nothing go wrong, I hope.
All right, well, I'll go ahead and get started then. So I'm Mandy Durbo. I'm the president of the Free Inquiry Group. And the Free Inquiry Group is a community of secular humanists who are dedicated to improving the human condition through rational inquiry and creative thinking, unfettered by superstition, religion, and other forms of dogma. Over the nearly 30 years that FIG has been in existence as a nonprofit, it has put up a temporary separation of church and state wall at the downtown at Fountain Square, protested the Creation Museum, and created what later became Camp Quest. So if you are interested in keeping in touch in our monthly speakers or finding out about what's going on locally, don't hesitate to check out our Facebook page, look at freeinquirygroup.org or gofigure.org will get you to the same place as well, and check out our meetup group as well. We are looking forward to working with Ben Hart and others as they develop the local FFRF group. And with that, I'll turn it over to William Messer, who is our programming chair.
Thank you, Mandy. Mandy is our brand new president, and I just thought I'd mention we created, not what would later become Camp Quest, but we created Camp Quest, and we ran it for 4 years until handing it over to American Atheists, I think it was, and eventually it became incorporated into itself. So we're very proud of Camp Quest having been ours, you know, from the start. So I will go straight to a little intro for Rebecca. As the legal director for the Freedom from Religion Foundation in Madison, Wisconsin, Rebecca S. Markert handles a First Amendment caseload that includes matters involving religion in the public schools, religious symbols on public property, and electioneering by churches. She served as co-counsel in federal lawsuits across the country, routinely assisting FFRFs, and which I'm going to say FERF, but I have no idea whether that's good or not. Cooperating attorneys in litigation, has drafted amicus briefs filed in many federal appellate courts, including the U.S. Supreme Court. Rebecca attended Roger Williams University School of Law in Bristol, Rhode Island, and received her Juris Doctor in 2008. She joined the foundation staff that same year as the first in-house staff attorney. She attended University of Wisconsin at Madison, received her BA in Political Science, International Relations, and German in 1998. So COVID-19 hasn't stopped SCOTUS from working, and several recent rulings have severe consequences for the increasingly fragile wall of separation between government and religion. As an educational watchdog organization working to protect the constitutionally mandated separation of government and religion, the Freedom from Religion Foundation has played an active role in bringing government-religion challenges to the court. Since 1977, FERF has brought more than 85 First Amendment lawsuits and keeps several establishment law challenges in the courts at all times. So Rebecca's going to be discussing at least 3 recent decisions by the Supreme Court and their ramifications, as well as a couple highly relevant cases that were held over from last year, which will be argued later this fall. At the conclusion of her presentation, she'll be taking questions, so hold them or put them into chat. And I'll try to keep an eye on all the chat questions. And when she's through, in the order they're received for the most part, I'll be asking them to her. So please make sure you're all muted, and please welcome with, you know, hand clapping that we won't hear, Rebecca S. Markert.
Hi, thank you so much for having me. I have genuinely missed being able to do these types of presentations. You know, I routinely travel around the country doing things like this, and obviously COVID has prevented us from doing a lot of that. So the only travel I'm doing lately is just usually coming to my office to get more office supplies or, you know, to prepare for something like this. So I'm happy that you guys invited me because I truly do love meeting different organizations and presenting, especially talking about my work. So I am going to share my screen here because I do have some slide presentations. So you're not going to see my face again until the end. So bear with me as I go ahead and share that screen and get the presentation up for you.
Okay, good.
All right. All right, so just loading. So hopefully you can see that now. So as I mentioned, I'm the legal director at the Freedom from Religion Foundation. And before we get started on tonight's topic, which is to review the Supreme Court's term, I wanted to give a brief background about FFRF. Some of you may be familiar with our work, but some may not be. So if you'll just indulge me for a moment, I'm going to tell you a little bit more about our organization and particularly our legal work. The Freedom from Religion Foundation is a national nonprofit organization. We have over 32,000 members across the country. We have members in every single state, the District of Columbia, and Puerto Rico. Our organization has two main purposes. One is to protect the constitutional principle of separation between state and church, and two, to educate the public on non-theism. So my department works on number one, keeping or trying to keep the wall of separation high and secure. These are three ways that we keep the wall intact.
Excuse me, Rebecca. Somebody is not unmuted and we're hearing background conversation. Would everybody make sure you are muted? Thank you. Sorry, Rebecca.
No, you're fine. Thank you. So my department works on number one, keeping or trying to keep the wall of separation high and secure. These are three ways that we do that through litigation, advocacy, and education. So obviously for litigation, we file lawsuits. William mentioned we've had over 85 First Amendment complaints. On average, we have about 10 to 12 ongoing lawsuits across the country at any given time. And we also resolve First Amendment violations through non-litigation advocacy as well. So we write letters to government officials when there's a state church violation. This is actually our preferred method of resolving complaints and is often very impactful. Our intake team weeds through about 3,000 to 4,000 contacts each year to determine whether there's something that we can work on. And we usually send about 1,000 to 1,200 letters of complaint or cease and desist letters. Again, they result in victories, meaning we don't have to go to court to stop the constitutional violation. And we're able to save the taxpayers' money that way. So it is definitely our preferred method. But we also advocate through lobbying. A few years ago, our organization expanded our efforts to lobby our state and federal government. We now have a lobbyist in Washington, D.C., and staff in Madison that are dedicated to lobbying efforts. We also educate the public on the importance of state-church separation. We do this through op-eds, letters to the editor, presentations like these, exposés, and our attorneys appearing on broadcasts like our program Ask an Atheist, which airs on Wednesdays at noon Central on Facebook Live, Free Thought Matters, and Free Thought Radio. So admittedly, our job is getting harder, and the Supreme Court and the federal bench have not helped. The hostile Supreme Court and the changing federal bench are very big challenges that we face. So let's turn to the theme of the night, reviewing the Supreme Court's most recent term. Religious liberty has been an area of the law where the court has had more of an interest lately, and it's also an area where the court has moved the needle the most. We have seen the court take more and more religious liberty cases over the years, and more we've seen them move from a strict separation between church and state, which defined the first 40 years or so of Establishment Clause jurisprudence, Traditionally, separation of state and church meant that the state couldn't pass a law that would aid religion, give financial support to religion, or prefer one religion over another, or over no religion at all. But slowly the court moved to a more permissive, also known as play in the joints line of thinking. In the 1980s through the 2000s, we started seeing that religion could get aid and they could be supported in some limited ways. But now, under the Roberts Court, we've seen the court dismantling the wall of separation of church and state at a rapid rate. Through the line of cases decided just this term, we can see two major themes emerging: the expansion of religious privilege through increasing exemptions, and a move from separation between state and church to one of non-discrimination. Churches cannot be prevented from receiving government aid just because they're churches. What we're seeing is a rapid redefinition of religious liberty where, quite frankly, Christianity is getting a favored status. They are seeking to reap government benefits, like getting aid, but then also avoid playing by the rules that other organizations have to play by claiming exemptions from non-discrimination. So these are the cases that we're going to discuss tonight. There were actually 4 that FFRF was involved in over the last term through amicus or friend of the court briefs, but these are the ones that really touched on religion. The first is Trump versus Pennsylvania, also known as the Little Sisters of the Poor case, which involved religious exemptions to the contraceptive coverage mandate under the Affordable Care Act. Our Lady of Guadalupe versus Morrissey-Berru, which involved the expansion of the ministerial exemption. And finally, what may be the biggest case turning our constitutional principles on their head, Espinoza versus Montana Department of Revenue. That case involved funding to private religious schools. We're going to start with Little Sisters. So one interesting tidbit about Little Sisters of the Poor is that the case was argued in May. It was supposed to be argued earlier, but was postponed because of the pandemic. So the interesting part of this is that the arguments were held via telephone and live arguments were accessible to the public for the first time ever. This case was a challenge by the states of Pennsylvania and New Jersey against a rule that the Trump administration created, providing an exemption for employers to opt out of contraceptive coverage for religious or moral reasons. As you may know, litigation over this mandate has been ongoing for years, and this is its latest challenge. Admittedly, there's a lot going on in this case, and it's not all involving religion alone. There are questions about the Administrative Procedures Act, how to promulgate a rule, when, things like that. Things that are actually not necessarily my area of expertise, but I'm going to try my best to explain it. So the Department of Health and Human Services needed to come up with rules regarding the mandate. As you may recall, the ACA requires birth control to be provided at no cost. Houses of worship and religious ministries were exempt, but the current administration gave for-profit groups also the ability to opt out for religious or moral objections. This means any employer can opt out. The Little Sisters of the Poor own and operate a chain of nursing homes, and they've been inserting themselves into this type of litigation pretty much since the beginning. So the Supreme Court decided 7-2 that the Trump administration had the authority to massively enlarge the contraceptive care exceptions and that its process for doing so was not procedurally improper. So employers have the right to opt out of the ACA contraceptive coverage mandate for religious reasons. It's essentially allowing your private reproductive health matters to be at the mercy of the religious beliefs of your employer. While the court ruled in favor of the Trump administration, it's important to note that it's not a definitive answer from the courts on the contraceptive exception for religious or moral reasons. The challenge remains live as to whether the rules are actually reasonable. The concurring opinion by Justice Kagan gets to that issue, which has not been resolved. Kagan wrote, "Other aspects of the department's handiwork may also prove arbitrary and capricious. For example, the departments allow even publicly traded corporations to claim a religious exemption. That option is unusual enough to raise a serious question about whether the departments adequately supported their choice." But one thing that I wanted to point out about this case is, and what's frankly been lost, is the burden. The nuns' whole argument is premised on the fact that their religion is burden. But keep in mind, they're exempt from the contraceptive mandate. So how can their religion be burdened? Well, in order to get the exemption, you have to fill out this form and let the government know that you're claiming the exemption. And that is a burden for the nuns. This form, a form that supposedly burdens the free exercise of religion of the schools, nuns, and nonprofits. This form is exactly 2 pages long, and there are only blanks on the first page. 5. You'll see I've counted them there for you. 5 blanks: the entity name, the name of the individual filling out the form, the mailing address, the signature, and the date. That's all you have to do. This is the challenge at the bottom of multiple Supreme Court cases. It's this that they're claiming burdens their free exercise rights. It's ludicrous. It's also funny that in Little Sisters, they also objected to the notice requirement. So the Trump administration's rule allows your employer to restrict providing that contraceptive coverage for you, and they don't even have to notify you of it. There's no notice requirement. And what I think is funny is that the Little Sisters have been spending years notifying everybody in the country that they object to this, but the notice requirement is also too big of a burden for them. So Justice Ruth Bader Ginsburg dissented in this case, and Justice Sotomayor joined. She argued that Congress, in crafting the ACA, intended to give women access to services like this, and that this ruling would mean between 70,000 and 125,000 women will lose access to birth control. She also pointed out the privilege given to religion here, and the quote is up here on the slide. She wrote, "Today, for the first time, the court casts totally aside countervailing rights and interests in its zeal to secure religious rights to the nth degree." So I'm going to turn now to another significant case that came down this term. This is Our Lady of Guadalupe versus Morrissey-Berru. So this is the case that after Bostock versus Clayton County came down, that was the case that prohibited discrimination against our LGBTQ friends in employment. Attorneys in the state church world were all waiting for this case, Our Lady of Guadalupe, because we anticipated it to be the butt to Bostock. It's the "you can't discriminate except if you're a religious organization" rule that we were all expecting. This decision is definitely starting to limit the reaches of Bostock and should be alarming. The court's decision involves 2 consolidated cases, both dealing with the ministerial exemption to civil rights laws, which allow religious organizations to fire their ministerial employees for any reason, even if it's because of race, sex, or another protected status. The First Amendment doesn't allow the government to get involved with the internal management decisions of religious institution. A church can fire its pastor. The government won't get into that dispute. This idea was furthered in another case, Hosanna Tabor, which stated again that the First Amendment forecloses certain employment discrimination claims, particularly when the employee was designated a minister. So the question becomes, what is a minister? You would think that that would be an obvious answer, but it is not. It's not just a priest or a pastor or somebody who's typically leading a house of worship. The questions become, when does an employee of a religious institution, any religious institution that, or religiously affiliated institution, become a minister? Is it when they have the title of a minister? Do they have to have religious training? Does the employee need to hold themselves out as a minister? Or do their job duties reflect that of a minister? So in this case, these are the questions that became relevant. So the plaintiffs in this case were 2 teachers at Catholic schools in California. They claimed they were discriminated against. Agnes Morrissey-Berru was a 5th and 6th grade teacher who taught all subjects at the Catholic school, but she was not a practicing Catholic, though she did teach there, and she taught religion. She sued the school for age discrimination after her contract was not renewed after 16 years as a teacher there, and her replacement was definitely a younger teacher. The school claimed she couldn't perform the work because there was a new reading and writing program, and they claimed the ministerial exemption. Kristen Beal, another plaintiff in the case, was a 5th grade teacher at St. James School in Los Angeles. She was being treated for breast cancer. She requested a leave of absence for treatment for that cancer and subsequently lost her job. Tragically, she died before the conclusion of this case. She never saw the end, but her husband carried it forward for her. Both teachers won the right to pursue their discrimination claims before the Ninth Circuit Court of Appeals, and the schools then appealed to the US Supreme Court. Here, the court rules in favor of the Catholic schools, again 7-2. They can discriminate against the teachers. The court finds these teachers are ministers for the purposes of the exemption. The court decides what matters most is the religious institution's explanation of the role of the employee. All the questions I listed before, job title, job duties, are relevant, but they're not necessarily definitive. Basically, the church decides what employees are ministers. How their job is defined by them is key. And in this case, the school saw the teachers, even when they taught secular subjects, as ministers. Justice Alito wrote for the majority of the court. He writes, "The religious education and formation of the students is the very reason for the existence of most private religious schools, and therefore the selection and supervision of the teachers upon whom the schools rely to do this work lie at the core of their mission. Judicial review of the way in which religious schools discharge those responsibilities would undermine the independence of religious institutions in a way that the First Amendment does not tolerate." Or, more simply put, when a school with a religious mission entrusts a teacher with the responsibility of educating and forming students in faith, judicial intervention into disputes between the school and the teacher threatens the school's independence in a way the First Amendment does not allow. So they're definitely expanding who is a minister. And when these decisions come down, we always look to the dissent for some sort of rational thinking and reason. Justice Sotomayor was killing it with dissents this term. So you will always hear about how fabulous Ruth Bader Ginsburg is, but Sotomayor has really come out swinging and has had some incredibly stinging dissents. This one was no different. I actually had a really hard time preparing for this without wanting to cut and paste everything from her dissent. She had a lot of really great quotes. In her dissent, which RBG joined, she said this ruling allows religious entities to discriminate and that it will have wide-ranging implications for other employees. She wrote, "It gives the employer," oops, I already had it up there, sorry, just going back. "It gives an employer free rein to discriminate because of race, sex, pregnancy, age, disability, or other traits protected by law when selecting or firing their ministers, even when the discrimination is wholly unrelated to the employer's religious beliefs or practices." What the court decided in this case is actually ripe for abuse. Sotomayor pointed this out. She wrote, "Over 100,000 secular teachers whose rights are at risk," and that says nothing of the rights of countless coaches, camp counselors, nurses, social service workers, in-house lawyers, media relations personnel, and many other workers who work for religious institutions. And this is actually what FFRF cautioned in our amicus brief before the court. We were unique in bringing up the healthcare aspect, and we were happy to be joined by the American Medical Women's Association in submitting our brief. Our brief pointed out that an expansion of the exemption could affect 1 million healthcare employees. So it's important to note that 15% of US hospitals are Catholic owned, and another 4% are owned by other religious institutions. And as you may know, many of the employees of these facilities are not Catholic or not religious at all. We know that this decision is going to let them game the system even more. At FFRF, we've seen this abuse in other contexts. We sued over the parsonage exemption in housing, where ministers of the gospel are allowed to deduct from their gross income their housing expenses. In that litigation, which unfortunately was not successful, we saw basketball coaches at private religious schools claiming the exemption. So exactly what Sotomayor said would be abusive. We've seen that play out. We know that it's going to get worse. Justice Sotomayor also pointed out the contradiction in the cases from this term, that the court is giving religious institutions a license to discriminate, but they also cannot be discriminated against. She was looking at the contradiction between Our Lady of Guadalupe and the Espinoza case, which we will discuss in a minute. She wrote, and it's up here on the screen, recently, this court has lamented a perceived discrimination against religion. Yet here it swings the pendulum in an extreme opposite direction, permitting religious entities to discriminate widely and with impunity. Finally, the Supreme Court held a huge blow to religious liberty with a bad decision in Espinoza versus Montana Department of Revenue. The court ruled that religious schools cannot be excluded from public funding. This case involved a neo-voucher law passed by the Montana legislature in 2015 to provide a dollar-for-dollar tax credit up to $150 for donors supporting scholarships for private schools. The Scholarship Opportunity Organization that facilitated this program in Montana supported 13 private schools, 12 of which were religiously affiliated. As a result, over 90% of the scholarships or taxpayer money went to fund religious education. So the Montana Department of Revenue then issued an administrative rule restricting the tax credit eligibility for scholarships to non-religious private schools. The department cited the state constitution's no aid provision. That provision read, the legislature, counties, cities, towns, school districts, and public corporations shall not make any direct or indirect appropriation or payment from any public fund or monies or any grant of lands or other property for any sectarian purpose, or to aid any church, school, academy, seminary, college, university, or other literary or scientific institution controlled in whole or in part by any church, sect, or denomination. So this provision was included in the state constitution when Montana became a state in 1889. But in 1972, they amended their constitution, but still ratified it with these words. So as you heard, the text is pretty clear, emphatic, and sweeping. There can be no money going to religious organizations. There are similar no aid provisions in roughly 30 states across the country. So here, 3 Christian families challenged the rule. Kendra Espinoza was a plaintiff, and she was a single mom with 2 daughters. There were also 2 other families. All of the families were low-income families looking to avail themselves of this private education. They argued that the rule that they were prohibited from taking this money to a private religious education program violated the federal constitution. The Montana Supreme Court in 2018 ruled against these parents. They invalidated the entire tax credit scholarship program and ruled that the no aid provision in the state constitution doesn't allow for these direct or indirect payments for sectarian education. Again, because the language is clear. The Montana Supreme Court scrapped the entire program, so there actually wasn't any discrimination. No private schools, religious or non-religious, were able to get the funds. There's actually legitimate arguments to be made that there was actually no controversy since the program no longer existed, and it should have never gone before the US Supreme Court in the first place. The dissent points that out later. So this case goes up to the Supreme Court, and the plaintiffs argue that banning the use of funding for religious schools violates their federal constitutional rights, and that this rule shows hostility, not neutrality towards religion. So they claim their case is bolstered by the 2017 Trinity Lutheran v. Comer case. You might remember that case. It was a case in which a Missouri church preschool sued because it was excluded from state funding to resurface its playground. The preschool won. The Supreme Court in that case basically said that whenever a religious group, person, or entity is denied a benefit from a neutral government program because of its status and not because of what it intends to do with the money, the government violates the free exercise clause. The plaintiffs here take that argument and also say that they are discriminated against. We submitted an amicus brief with our other secular organizations in this case as well. We were joined by the Center for Inquiry, American Atheists, and the American Humanist Association. Our brief argued that the plaintiffs had it backward. We wrote, quote, "Religious liberty is imperiled in this case, but this case is not about discrimination. It's about government-compelled support of religion. Every Montana citizen has the right not to be taxed to fund religion." Our brief also asserted that, quote, "Religious freedom means that no citizen can be compelled to subsidize a religion that is not their own. If this court abandons this basic principle, we will have reached a disastrous moment in American history, the era of government-compelled tithing." But in a 5-4 decision, this is what the court does. It says if there is public funding available, churches must be included as recipients. Chief Justice Roberts wrote for the court. He wrote, "A state need not subsidize private education, but once a state decides to do so, it cannot disqualify some private schools solely because they are religious." Again, we're going to look at the dissents for some rational thought. They noted the odd posture of the case, namely that the court needn't even review it. Justice Ruth Bader Ginsburg, joined by Justice Elena Kagan, pointed out that the Montana Supreme Court had made no distinction between religious and non-religious schools. She wrote, "Because Montana's Supreme Court did not make such a decision, its judgment put all private school parents in the same boat. This court had no occasion to address the matter. The state court struck down the program in full. In doing so, the court never made religious schools ineligible for an otherwise available benefit, and it never decided that the free exercise clause would allow that outcome." Justice Sonia Sotomayor also dissented. She wrote, "Today's ruling is perverse. Without any need or power to do so, the court appears to require a state to reinstate a tax credit program that the Constitution did not demand in the first place. The court rejects the religion clause's balanced values in favor of a new theory of free exercise, and it does so only by setting aside well-established judicial constraints." She also concluded that it violated the separation of church and state. Because this decision further slights both our precedents and our history and weakens the country's longstanding commitment to a separation of church and state beneficial to both, I respectfully dissent. So the impact of this decision cannot be overstated. It's not good. From the beginning, we've argued that this case was not about discrimination as posited by the plaintiffs, but about government-compelled support of religion. Every citizen, in this case every Montana citizen, has the right not to be taxed to fund religion. This is a basic constitutional principle. The founders agreed with this principle. Abandoning this principle results in government tithing. Unfortunately, the court did just that and is now forcing taxpayers to fund religious education. But it's also going to be calling into question other government funding cases. It could be argued that this now means that when public money is doled out in other contexts, the government cannot discriminate and religion is entitled to government funding. This is actually happening now. With the pandemic, the federal government has been giving out funds to help organizations stay afloat. Under the Paycheck Protection Program, religious organizations have amassed $7.3 billion, with megachurches and thousands of Catholic dioceses amassing millions. This giveaway to churches is the first time in U.S. history that tax funds have been directly used to pay the salaries of ministers and religious staff for religious purposes. Given Espinoza, there is a little bit of reason to worry that this funding would be constitutional as well. Espinoza also brings up the point that Sotomayor brought up in Our Lady of Guadalupe, that churches want their cake and to eat it too. They cannot be discriminated against, but they have a license to discriminate. Funding to the religious schools definitely makes taxpayers fund discrimination. Private religious schools have turned away LGBTQ families, and they have fired women for becoming pregnant or not being married. So the question then becomes, is this the end? Well, of course not. Not really. It's a very bad decision, but the court did make a distinction between religious status and use. The court said you can't discriminate based on status, but it's possible you can prohibit funding based on use. For example, a restriction on direct funding to religious education classes may be permissible. We lawyers are going to evaluate the cases based on the facts of each one and make the distinctions that are necessary. They're actually doing that in South Carolina right now, where some funds for COVID have been diverted to religious schools. It's an uphill battle, but FFRF is definitely up for the fight. And the fight is going to continue next term. FFRF submitted another amicus brief in a case that will be argued in November. It'll be actually November 4th, the day after the election. In Fulton versus City of Philadelphia, this case involves Catholic Social Services, one of 30 agencies that Philadelphia contracted with to place abused and neglected children into new homes. The City of Philadelphia properly ended its contract with the Catholic group in 2018 after learning that it would not place children with LGBTQ families as foster parents. The Third Circuit Court of Appeals ruled in favor of the city, noting that religious belief will not excuse compliance with general civil rights laws. SCOTUS granted review, and we're worried that this is a bad sign. So we came out swinging in our brief. In our brief, we asserted that, quote, in practice, CSS has instituted a policy of religious liberty for me, but not for thee. The Catholic Social Services assertion that it's a private entity in this context with a right to discriminate disregards also the nature of the foster care system and the fact that the government contracted with the agency to place children in homes. If CSS is permitted to discriminate in this case, the rights of religious minorities and the non-religious are also going to be in peril. The consequences if Catholic Social Services wins this case will be far-reaching. Religious right legal groups are seeking to overturn important precedent. One of those is Employment Division versus Smith. That's a 1990 case in which the Supreme Court ruled that religion does not exempt a person from a neutral, local, state, or federal law. The Smith case upheld the denial of unemployment benefits to 2 prison guards who were fired for using peyote, an illegal substance. Then Justice Antonin Scalia, affirming the Smith decision, noted that laws may not interfere with mere religious belief, but may interfere with actions. Otherwise, he warned, every citizen professing his religious belief is superior to the law would become a law unto himself. Catholic Social Services argues that it must be allowed to discriminate because its contract with the government involves religious activities. FFRF's brief wrote, this absurd position becomes a nationwide nightmare if the court, in the aftermath of Espinoza, overturns Smith and finds that the program regulations simply do not apply to religious organizations if the religious organizations say so. In short, we wrote, when the party to whom the rule applies decides whether the rule applies, there is no rule. We concluded by saying any readily available exemptions from laws governing these programs for religious groups would put them in a favored position and create an imbalance of constitutional rights. In keeping with our bedrock principles underlying the Free Exercise Clause and the Establishment Clause, the appropriate standard in this case is religious neutrality. So, as mentioned at the outset, we have many challenges before us. The majority of this presentation has been about our hostile Supreme Court. Like I said, we see them moving further away from true religious liberty to religious privilege. We see the trends I mentioned earlier, moving away from strict separation of church and state to increasing exemptions, thereby solidifying this religious privilege. And it's also concerning that 2 of these cases were decided 7-2. They got Kagan and Breyer. So it's not necessarily a friendly court for state-church separation. In fact, I went through because Kagan is surprising to me. I would have thought she would have been on side of state-church separation here. And when I tallied, and this is not the way that you should try to figure out where doctrine is going, but when I tallied all the religious liberty cases since Kagan's been on the court, she's 50-50. She's definitely not a strong state church justice. But another alarming challenge is the change to our federal bench. The Trump administration has appointed over 200 judges in just 4 years. These judges are often young, which is very important for a lifetime appointment. They're white, and they're extreme in their views. And it's also upsetting given how many cases the lower courts handle. I've personally seen lower court judges put into an opinion that the Establishment Clause doesn't apply to the states. This is an extreme position that I've not seen in any actual opinion. It's just been an aside saying, we don't think that this is actually incorporated against the states. But now we have a real possibility that this is going to become mainstream. This means that we have to change our tactics to keep state church separate. Litigation isn't going to necessarily be the answer. So what can we do? Well, the first thing I will tell you to do is join FFRF. You can join on our website and become a member and help us do this fight. I also would urge you to come out of the closet. Let people know that you're a non-believer. The more people know, the less intimidating it will seem, and the more likely they'll accept you. I also want everybody to contact their representatives. It is really important right now to register dissent, even when your representatives disagree with you, even when you already know the way that they're going to vote. Also, if you know that they're voting the right way, contact them and show them their support, because in some of these states, like my home state of Wisconsin, taking the right position can be a death knell for some of these politicians. So they need to hear when they've done something right as well. And finally, you need to make sure to vote. I work for a nonpartisan organization, a 501c3 organization. So I can only say in this regard that you need to educate yourself, find out where the candidates stand on the issues, and vote in favor of state church separation. So with that, I'd like to take some questions. I'm not sure what time it is, but if you are available for questions, or if you guys have questions, I'm happy to spend some time answering them.
There, I'm finally unmuted. You're fine. You're fine in time.
I just
in
given
fact,
everybody
we-
permission to unmute themselves, so
I wouldn't do that, Peter.
it's done.
Not yet.
Don't unmute
Not
yourself if you're just gonna make noise. Unmute yourself if you have a question.
So Rebecca, as we're waiting for questions to come. Oh, finally, we do
You have
have
three
one.
there.
So what do you think about Justice Roberts? This comes from Scott Seidowitz. Oh, you're muted, Rebecca.
All right.
There you go.
I've always been concerned about Chief Justice Roberts. I know that he's been heralded recently, even in this most recent term, because he has made some decisions that people feel are good. The decision in the abortion case in Louisiana, people were very excited about that decision because he's upholding precedent. When the court really is taking cases that have issues in them that were already decided a few years ago. And that usually doesn't happen very often with the Supreme Court. Usually they will have a decision and it may be a decade before they discuss that case again. But we saw with some of these abortion cases that, you know, one abortion case was decided in Texas, and 4 years later, it comes up in Louisiana, and the Supreme Court took it. We were very nervous about that, but Roberts came down apparently on the right side of things. The problem I see with Roberts is that he says a lot of the right things, but then he also puts in footnotes how he's just planting things to be overturned later. So in a footnote, he'll just mention, for example, you know, how the Trump administration could do this better. There have been, I think it was in the DACA decision, he basically said that the Trump administration was just bad at the APA, and that, you know, if they try it this way, it might be constitutional. And I see that as what's upsetting. He seems like he's for precedent, but he plants a lot of seeds so that later he can overturn something because he's created the precedent allowing him to do so. So I don't think that he's our friend necessarily. I do think it's super interesting that the Chief Justice, for the first time in a really long time, has become the swing vote. But I don't think that he's necessarily friendly to state church separation. So at least in terms of our issues, I don't think that he's going to be any sort of, forgive the term, savior for us.
Yeah, Kagan's a big surprise. Ginny writes, how do we come to have 200 openings in the lower courts?
Oh, well, that's actually because of Mitch McConnell. During the Obama administration, the Senate halted a lot of the appointments and confirmations of the judges that were being appointed to the federal bench. So federal courts across the country were running at a deficit. And then, of course, the most famous way that they did that was with Justice Merrick Garland, when they refused to even hold a hearing for him during the last year of Obama's presidency, because they claimed it was an election year and they wanted the American people to decide. So they really set this in motion, where there were a lot of vacancies. They did not let the previous administration fill them. And then once the Trump administration came in, one of his promises was to fill these seats very quickly, and they have been doing that. There were some changes in some of the Senate rules that allowed them to do it at a pretty rapid rate, but they don't always play by the rules. We know that. They've also toyed with the idea of recess appointments and things like that. So they've made this a priority, and they know that changing the federal bench in this way, not just the Supreme Court, but the lower federal courts, means that they're going to be stalemating progressive doctrine for decades. And so it really, it was definitely a targeted approach to make sure that the courts would move over into a conservative bent, especially for state church separation.
So Elaine writes, how do you frame the issue of religious special privilege for religious schools to voters who will be voting for an equality ordinance this fall? The school will be framing the issue in terms of discriminating against them. They want a total exemption instead of limited to teachers.
I'm not quite sure I understand that question. I'm trying to read it here in the chat.
Elaine, do you want to unmute and clarify? Well, if you like, we can take Dan's question and come back when Elaine can. Elaine, Peter, is she able to unmute?
Elaine is unmuted.
Okay, go Elaine.
Okay, sorry, I had my headphones on. The village that I live in passed the equality ordinance, and
What do you mean by equality ordinance?
It's in the village of Gulf Manor, and it's an ordinance not to discriminate against people of protected classes, and of course they included LGBT and Q.
Okay.
And as you start your video, okay, got it. And so the school in the village is, gone on for over a year trying to get it right and trying to make everybody happy. And and I know that they are going to send literature around stating that we want to discriminate and not let them hire who they want to hire for teaching. And that's not it at all. We just don't, we just wanted the special exemptions limited to teachers, and they shouldn't have an exemption for property that they own in the village. In other words, they have to be able to rent the property just like anybody else to whoever they want, whoever wants to rent it, not to just people of their religion. So it's more or less, and I know this is a little bit out of your rim because you're a lawyer, not PR, but we have the task of educating the rest of the people in the village so they vote for the equality ordinance. And I just wondered if you had anything about how that should be framed.
Well, do you know if the equality ordinance has an exemption for religious organizations?
Yes, it does. Yes, it does. The issue is that they wanted a total exemption, and the one that we hashed out is an exemption for things that are for religious reasons, but not, like they can't discriminate when they hire a custodian.
Right.
Things like that.
Right. I mean, I think that is the right way to frame that. I think that what's important for PR purposes is probably just highlighting how many people take jobs at religious institutions and religious affiliated institutions but don't actually share in that religion. I mean, especially now during a pandemic when there's a lot of people who are out of work and they're taking what they can get. It is, it is patently unfair to make them sign statements of faith and designating them ministers. The Our Lady of Guadalupe case is mind-boggling to me because those teachers, the one who didn't even consider herself a practicing Catholic, was deemed a minister for the Catholic Church. I mean, that doesn't make sense to anybody. And I think pointing those things out, just the genuine unfairness of it, and reminding people that one of the greatest things about living in America and our American principles is that we have this uniquely American ideal with a separation of state and church, but also this idea of freedom of conscience. And that needs to be upheld. So, I mean, I'm not sure if that helps, and I'm definitely not
help.
in PR,
Yeah, it does help,
but
especially like
I mean,
because it does help because I mean, we thought we had a good ordinance and we thought we had agreement with them, and then after it passed council, after a year of litigation, and they went around and got a petition and had just enough people to sign it to put it on the ballot.
yeah, no, that's really frustrating. I mean, there is definitely this type of thing is definitely ripe for abuse. And I'm sure if you went and did some research, there are countless stories of how people have been discriminated against in horrible, awful ways because of these religious exemptions. I mean, aside from women getting fired because they got pregnant out of wedlock, or, I mean, the woman in the Beale case, she got fired because she was fighting breast cancer. I mean, I would think that people would find that horrifying. And these are the type, I mean, the biggest thing with PR, and is something that FFRF is trying to be better at, is the storytelling. Here are the problems with this proposed ordinance the way that you have it, and here's how it's played out in other areas, and finding those stories that really highlight and really slap people in the face and let them understand what they're voting for. This was one of the things I think also from the Trinity Lutheran case from 2017. They were so good at their storytelling because when you look up stories about that case, all you see is children's playgrounds and all you hear about is children hurting themselves, and how could anybody, you know, be against these children getting a new playground surface, when the actual issue in the case was, is it okay for the state to fund religion? But they changed that narrative, and that's the type of thing that we need to become better at. And I really think like highlighting some of these real life stories where people are dying of breast cancer and they get fired, and the religious institution is okay with that. Those are the types of things that we need to highlight so they really understand, because the religious right and the religious groups are really good at playing those stories out, and we need to become better with that. And I think that this storytelling and just really showing how it impacts real life people, especially if you have any of those examples in your community, are going to be really powerful.
Okay, thanks. Thanks a lot.
So Rebecca, speaking of framing the issue, religious people tend to think anything they do is a ministry. It's
Yes.
all part of their religious mission. And that's because of how they frame things in their world, you know. So how can we define the concept of, quotes, religious liberty so that it falls more in line with the Establishment Clause and not so much with the Exercise Clause?
Right, and that is a huge challenge, because they've done a really good job of redefining what religious liberty is, and showing that it's don't discriminate against me. So we really have to, I think, get back to these core principles that our founders had enunciated and then proclaimed, because this is what true religious liberty is. You can't have true religious liberty unless the government is free from religion and our government policies are free from religion. We need to be able to have everybody live with a true freedom of conscience in order to secure these religious liberty rights. And really turning the conversation to, if this is the way that we're going, if these laws and the way that courts are interpreting them are the way that we're going, it actually hurts religious liberty, and it hurts religious liberty for Christians as well. So I think it's a really big task, and there are tons of books that are actually coming out now about that. How do we reclaim religious liberty? Because the Christian nationalists have really taken and run with it, and have been screaming about this persecution, or purported persecution, for so long. So I don't have a lot of definitive ideas other than getting back to what is a uniquely American principle and why we should be proud of that, and why state-church separation is so important for religious liberty. I mean, state-church separation affects every issue that you can think of. You know, people are upset about immigration policies. Well, we had an attorney general who was basing some of these policies on the Bible, and nobody wants that. If you're upset about kids being in cages, then let's look at why these elected officials are doing that. Are they basing it on their own personal religion? Again, telling these types of stories to change the narrative. I do think that we have great promise in the younger generation, who is very active and political and understands a lot about diversity and tolerance, and they don't put up with a lot of things. And so I feel that the future is bright, and I think that really targeting them and getting them to understand why state-church separation and the Establishment Clause is so important is key in all of this, in reclaiming religious liberty. Because I can also tell you that I have gone to many different colleges and universities and talked about FFRF's work, and I've had students, as bright and promising as I see them, also tell me that, you know, they don't really care if a house of worship has a soup kitchen, because if our government's not providing that benefit or that help, assistance that's desperately needed, then somebody needs to pick up the slack. Problem with that, of course, as we know, is that most of the time there are a lot of strings attached to this assistance, and there's a lot of proselytizing that goes on. But again, they don't see that as an issue, and we need to start highlighting these issues for them so that they can understand that some of the rights that they're caring about right now does go back to state church separation. And if we had a strict separation of state and church, some of these other rights that aren't necessarily just about religious liberty will also be secure.
You know, in line with the your feeling we had to tell better stories, and something you said just now in this answer, they come together really well. You said, this is what true religious liberty is. And that could be a whole campaign that shows people what true religious liberty is.
Yes.
And anyway, we've got a couple questions piling up here. Dan asks, is there any litigation about Trump's 2017 executive order disabling the Johnson Amendment so churches can take political sides and retain tax-exempt status? Both parties this year are doing rallies in churches.
Well, I could tell you that FFRF sued when that religious order came down. And one of the biggest fallacies coming out of this is that they actually did something to the Johnson Amendment. The executive order actually didn't change that much, but because the administration was running around saying that they had disabled the amendment, and they, you know, I think his exact quote was that they utterly destroyed the Johnson Amendment. We did sue over that, and we got the department, we got them to admit in court that actually nothing had changed, that the Johnson Amendment was still in effect, and that it still had force of law. The problem is with the Johnson Amendment is, yes, the IRS will take these complaints, and they are tasked with enforcing this amendment, which, if anybody doesn't understand, the Johnson Amendment is a provision in the tax code that prevents tax-exempt organizations, particularly 501c3 organizations, from opposing or supporting candidates for elected office. So FFRF and churches cannot tell you who to vote for. But obviously, we know that that happens all the time with churches, and FFRF takes these cases and takes these complaints to the IRS saying, hey, you need to investigate. And then the IRS has the ability to go through, investigate, see if the amendment was violated, and then punish them in some way, usually by revoking their tax-exempt status. It's not even revoked forever. Usually it's just for a couple of years or so. The problem is that the IRS is woefully underfunded, incredibly behind on everything. I'm still waiting for my federal tax return, but they don't have the resources available to enforce this provision. And quite frankly, the administration right now is not devoting a lot of resources to it because they don't want to. They want to keep funding low, and they want these investigations to not go full throttle. But we got them to admit in litigation that it is still the law, and that they do have procedures in place to enforce that. We do file complaints with the IRS every time we hear about a church supporting or opposing a candidate from both sides of the aisle. I have written to the IRS about churches that have endorsed Obama, that have endorsed Hillary Clinton just as much as, against Trump. There was actually one church, I think in 2016, where the pastor got up and was like, I don't think you should vote for any of them. They're all bad. That's even a statement that would be problematic. But it is another one of those things that I think a public relations campaign will also help, because the majority of Americans support this amendment. There was a survey by Lifeway Research, which is a Baptist organization, that showed that 8 out of 10 Americans support the Johnson Amendment. And this makes sense. It's a great it's a great little tidbit to tell people, because it makes sense. When you're sitting anywhere, whether it be in a pew or anywhere, or just on Facebook, nobody likes to be told who to vote for and why. And they don't want their pastors doing that either. And the other interesting thing about the Johnson Amendment is that it is an area of the law where FFRF, which largely deals with people who are non-religious, our complaints are coming from people who are sitting in church pews, and they're saying, hey, I was at church this Sunday and my pastor told me this, and I don't think that's right. I came home, I looked it up, and I found you guys, and I would like you to do something. So I guess to get back to your question, we have sued. It's still law. The problem is enforcement right now, and we're still complaining, just to let those complaints pile up, and let them know that there's still people who are dissenting about that. But we also are doing this public education campaign also to remind people that the Johnson Amendment exists, that the majority of Americans agree with it, and that it is important for churches not to get involved in politics, and why that's important, and why we want public charities and 501c3 organizations to remain committed to their public charity work and not get into politics.
You know, Baptists have a long history regarding separation of church and state support, from Americans United to all the way back to the relationship with Jefferson. You know,
Yes.
so very interesting. So, a quick question. We grew out of the Center for Inquiry, FIG did. How good an ally have they been?
Oh, they're a great ally, actually. I am very good friends with Nick Little, who's the general counsel over there, and he and I talk regularly about a lot of the work that they're doing, and how we can help them and how they can help us. And actually, all of the groups have been really good about that. A few years ago, we were at, the Freedom from Religion Foundation is part of the Secular Coalition for America, and every year they have a members meeting. And I went to one of them and met up with Allison Gill, who is the legal director over at American Atheists. And we sat down and we decided that what we wanted to do was bring together all the secular litigators from CFI, from American Humanist Association, American Atheists, and FFRF, and get together and really start strategizing together in a cohesive movement so that we are, we're more impactful. And so we started the Secular Litigators Roundtable, and every year we meet once in person, usually in Washington, D.C., because that's where everybody is. So my attorneys and me fly out there. But then we also have quarterly calls. And one of the crowning achievements, I think, from this Secular Litigators idea is that we also have gotten Americans United and the ACLU on board. And why that's important is because a lot of those attorneys have been working far longer in this field than we have. And so we're really able to also learn from them, but then also, share ideas. And, we're still like the younger groups. We have a lot of green ideas and passion. And so there's a lot of times where they're not really excited about taking a particular case, and we talk it through and really get them to come on board or support us in some way. So we've actually, over the last few years, I feel like it's been 4 or 5 years now, we've really gotten a really good group. And CFI has definitely been a big supporter of that. Plus, I really love Nick. He's a lot of fun, and he's a Packers fan, and I'm from Wisconsin and a Packers fan, so makes me happy.
Cheesehead. So Mandy mentioned that sometimes Christians understand it when you bring up Sharia law. How would they like it if a Muslim or a Satanist were proselytizing at work to their kids at school? That's always been a useful tactic. somebody named Peter Lloyd wrote, if the Espinoza case went to, does that mean that there were other similar cases in other states that needed higher court to resolve? What about those cases? Oh,
So
Matt
That was me passing on a
asked it,
message.
actually.
That was me passing on a question from Lynn to me privately, so I made it public, that's all.
So I had
Okay.
it cut out a little bit there. So can you repeat that?
Are you showing the chat?
Yeah, I'm looking for it right now. Is there?
Okay, it says from Peter Lloyd. Oh no, it was sent privately to me. All right,
Okay.
if the Espinoza case, but it's for everybody, I think. If the Espinoza case went to SCOTUS, does this mean that there were other similar cases in other states that needed the higher court to resolve? What about those cases?
No, this is one of those situations too where this court is really sort of doing things differently. We've seen a lot of cases that the court has taken when they don't need to take them. The Espinoza case is one of them. I had mentioned that the Montana Supreme Court invalidated the entire program. So the state of Montana actually got rid of that program. So one of the things that federal courts need to do in order to review a case, to have the authority to review a case, is there needs to be a case in controversy. And there was no controversy because there was no case, there's no program, but they took that case anyway. And that is upsetting. They are taking cases when there is no circuit split. Like you mentioned, there weren't other courts. That it wasn't the situation where there are 3 circuits that say this and 4 circuits that say this, and the law needs to be interpreted for everybody to be doing the same thing. That's not the case. That was not the case in Espinoza, unfortunately. And we've seen that in other cases as well. I'm trying to think of what was the other example where, you know, there was no controversy at all and there was no reason to even take the case. It's eluding me right now, but we've definitely seen this court sort of not take that procedurally proper thing to do and to just take things because they want a particular outcome, unfortunately. And that, quite frankly, is what Roberts needs to contend with. He's very concerned about the integrity of the court and making sure that it doesn't seem political. And I think this is probably also one of the reasons we're seeing Kagan flip-flop so much on this issue too, is because they're working sort of in concert to make sure that the Supreme Court still seems like an independent institution and that it's not looking for certain political outcomes. And yeah, so we see them taking wildly crazy cases for no reason at all. And that's unfortunate. But yes, in Espinoza, there weren't a whole lot of cases around the country that the court needed to resolve the issue.
So someone asked privately whether or not you could make the slides you showed available.
Yeah, I could do that.
Okay. And while I wait for another question, I have a few.
Okay.
Do you think SCOTUS is sexist?
Do I think they're sexist? I mean, do I take the tack that Ruth Bader Ginsburg does with there are not enough women on the Supreme Court? Yes, I would agree with that. But sexist in their decision making, I think that would be a little harder for me to answer because I feel that that would take a more comprehensive review of all the cases that they have been reviewing to see if there is any sort of sexist bent to it. But should there be more women on the court? Absolutely. Would it be awesome if one of those women was also non-religious? Yes. Is everybody still there? I think everything's frozen.
I think, can
My
you hear me?
connection is broken down. I'll try again.
Okay.
Can you
This
hear me?
this came from Dirk and Karen. What are
Okay,
your
good.
thoughts
Yeah,
about
Peter.
What are your thoughts about the group Indivisible?
Is Indivisible the group of former staffers from the Obama administration? Is that?
Dirk and Karen, do you want to unmute and clarify?
Okay, yeah, that's the group I'm talking about.
Okay. Yeah, so I don't know a whole lot about them other than I was also a former congressional staffer, and so I have given presentations too on how to lobby, especially if you're an atheist, agnostic, or humanist. What's effective lobbying look like? And their line of thinking is obviously very similar to mine. Being on the inside like that, like I do agree with a lot of the strategies that they list. You know, if you are contacting a representative, what's the best way to do that? I would definitely agree that calling your representative is the best way to get through to that representative. I can tell you from my own personal experience when I worked in Senator Feingold's office, this is way back when you might remember the child Elias Gonzalez, who was coming to the United States from Cuba. And his mother died on that voyage, and then he was sent to live with his family in Florida, but his dad wanted him back in Cuba, and so they were fighting over whether to send him back, whether to keep him here. And our phones were flooded at the senator's office, so much so that our front office staff couldn't keep up. And we ended up instituting a rotation where every single staffer had to go out and take a turn at the phones. And this wasn't just junior level staffers. We had senior policy advisors out on the phones as well, because it was so overwhelming. And when you get a senior policy advisor taking a call, you can rest assured that the senator is going to hear about that, because, you know, like I couldn't get that memo to you today because I had to take a turn on the phones because we've just been inundated. And so they have made recommendations like that that I think are very true. What I've seen them publish, I would agree with, especially
Okay,
in
great.
terms
I
of
mean,
strategy.
there's a book called We Are Indivisible by Leah Greenberg. She was a staffer. And there are a lot of excellent ideas about democracy and how we can restore democracy to America. You know, the courts, the media, the voting rights, numerous things, Congress.
Yeah, that would be interesting. I mean, again, I know that they had been publishing a lot of how to contact your representatives, and that's the stuff I'm most familiar with. And so I definitely agreed and thought that what they were advising was correct, especially from my perspective. But I'm interested in learning more about that book. It might be interesting and helpful.
Apparently they have groups in every congressional district in the US. So hopefully they can affect some of these elections.
Yeah.
So Lynn asked, respecting the litigation work group that you've been putting together, do you guys have a list of judges to offer Biden and Harris, hopefully, who will be installed in the White House next to consider for future appointments?
You know, it's interesting that you asked that. The secular litigators group does not. We haven't been focused on that. We've been mostly focusing on what should our strategy be with regards to litigation. But FFRF has another aspect of our office, which is lobbying and strategic response. And what we've been doing there is looking at how can we affect the courts and the makeup of the courts. And so through that, we actually became members of the Leadership Conference for Civil Rights. And that conference has a Fair Courts project. And it's interesting that you bring this question up, because just 2 weeks ago, I had a call with the director of that program to try to figure out how can we be helpful to make sure that the courts are fair. And one of the ideas that came from that meeting was coming up with a list of judges, not only on the federal bench. I mean, I think that it goes also to state courts and municipal courts and things like that. I think it's really important to encourage people, particularly women, to run for judges, and have people who are non-religious run for judgeships. I'm really excited because one of our former interns here at FFRF, someone who I know is an atheist, is also running for judge. It's not in a federal, obviously not a federal position because she's running for an election, but I think those types of things are important. But yes, we're looking at coming up with lists of judges that will be good. It's hard because even though we have a national membership, we're still a pretty small office, and you know, the makeup of the federal courts is not our bread and butter work, and it's not necessarily our mission. So we really have to partner with these other organizations who are better equipped to really move the needle in that way. But it is something that we're going to be looking at no matter who gets into office in November.
So we've exhausted the chat questions, but I have a couple sort of more personal questions for you, and we were about 10 minutes late in getting started. If you're okay with maybe going to...
Oh yeah, absolutely.
So one of them was, how do you feel representing and working for atheists?
That's a good question. You know, at first I thought that I found myself, when I first started working here, I found myself not feeling up, you know, let me start again. So when I first started working at FFRF, if I were out and about in the Madison area, which is a fairly progressive area, it's a college town, you know, I wasn't afraid to tell people where I worked. But if I were to leave my little bubble here and go to what would be traditionally more conservative parts of the state, or my hometown of Green Bay, I would always kind of say, I work for a nonprofit, we do civil liberties work, and then see if people press. But now I've really moved away from that because I think that once I explain to people what I do, their perspectives change, whether they're religious or not. When I talk about representing atheists and agnostics, you know, it's not just about we want to get "In God We Trust" off the money, or we want to fight the pledge. But when I tell them, you know, on a day-to-day basis, I'm dealing with a kindergarten teacher who is proselytizing to a 5-year-old. I'm dealing with a public school football coach who went unbeknownst to the parents and baptized his team in the public school swimming pool. When I start telling stories like that, people, even if they're religious, start saying, that still happens? That's crazy. And they really start respecting the work. So I've definitely, I mean, it's been an evolution, but I've gotten more comfortable saying where I work. And another personal story to this point is that I grew up Catholic, I went to Catholic school, and one of my uncles is a Catholic priest. He was a Catholic priest. He died a few years ago. But I remember one Thanksgiving when I walked into the house where we were celebrating, and a few weeks earlier, it was an election year, and I had just sent in to the IRS a bunch of letters about the Catholic diocese getting involved in a political campaign. And I walked in, and he said to me, you know, Rebecca, I saw your name in the paper recently. And I was a little nervous. I was like, oh, really? Like, kind of shying away. And he said, I was so proud, atta girl. Like, I think that these issues are inappropriate for the Catholic Church to be engaging in. And that really made me feel more confident also about going out and doing this work, because it really is work that needs to be done. And, you know, just as a lawyer, everybody deserves their defense and their day in court. And I was trained to do that and represent anybody, and I understand how important constitutional rights are. So I'm not really worried about who the person is, what they believe, what they don't believe. What I want to do is make sure that their constitutional rights are upheld.
Well, speaking of the pledge, if you watched the RNC recently, several of them warned everyone that if they vote for Biden, they'll be voting to remove God from the Pledge of Allegiance under God.
Well, this is what I also think
Is this something FFRF is working toward, restoring the pledge?
You know, we haven't been really that active on it, and it's definitely not something that our legal department is doing. I mean, obviously, when the issue comes up, we always remind people what the original pledge looked like. We actually have a copy of the original pledge up in our office here in Freethought Hall in Madison, and I like to explain the real story behind the pledge. I mean, there are a lot of people out there who believe that under God has always been in the pledge, and that that's the way that it was originally written. And when you explain the history and the context behind it, they are interested in hearing that. But right now, it's not one of our main focuses.
Okay. Well, also explaining that one nation indivisible makes a lot more than what seems to say an indivisible God wedged in there. So we have Scott Seidowitz suggests that if a non-theist is running for judge or any other office, that person should apply for an endorsement or contribution from the Free Thought Equality Fund, which is a PAC connected with the American Humanist Association. And Kat, our former president, has asked, what can we, the Free Inquiry Group, do to assist your work?
Well, again, I think that one of the good things is that you can be members of many different organizations. And if you become a member of Freedom from Religion Foundation, obviously, I hate to say it, but you know, those financial contributions are what's going to really help us fund our team and keep our work going. All of the lawsuits that we take are pro bono. We do get legal fees if we win a case that comes back to our organization. But it's at no cost to any of our plaintiffs. It's really funded by the organization's membership dues. So that's a big thing that you guys could do. But the other stuff is stuff like this, having these types of presentations so that we can talk about our issues. If there's an issue going on in your part of Ohio, if you want to contact our office to let us know how we can help. If we start having a dialogue, if there is something that's happening in that part of the state, we can call on you for help as well. You know, a lot of times there is an op-ed that we want to run. That's going to be more impactful coming from somebody who lives there versus the hardest thing for FFRF is that we are always the outside organization coming into a community. Even if we say we are working on behalf of somebody who lives there, we're always the outside organization. So if we have people who are willing to write letters to the editor, op-eds, or go to a town meeting and speak up about whatever ordinance it is that they disagree with, or whatever discrimination is going on against non-religious people, that's going to help our work significantly. Right now, the biggest thing that we can do is just increase our presence publicly so that people, this stigma of atheists, agnostics really dissipates.
Well, since you're the legal eagle in this virtual room, we're a 501c3 organization. Are we permitted to, and is it something you would like us to like sign on to for a case you're doing, or is that inappropriate?
To sign on to an amicus, did you say?
Yeah, right.
Yeah, usually what we would do in that case is if it is relevant to the area in which you are. So if there were a case that were going to the Sixth Circuit Court of Appeals, which encompasses Ohio, that might be something that you guys could do. But if we're doing something in the Ninth Circuit, it's not going to be really, the court's not going to be impressed that a group based in Ohio
Right.
is also getting involved. So if it's a regional thing, absolutely, that would be helpful, and we could see if that works.
And that wouldn't violate or exempt our exemption. That wouldn't affect it really.
No, not in terms, I mean, the provisions that you'd be most concerned about would be those electioneering provisions where you can't
Okay.
endorse or oppose a candidate for office. But there have been other organizations that have joined on to amicus briefs in the past as well. It also helps courts to let us know that we have a backing of people in that area.
One thing I would like to ask is that anybody who is here that is a member of the Freedom from Religion Foundation now, we are starting a local chapter. If you want to get in touch with me and become a charter member, very much my email address is bandy, BANDY, 1939 at yahoo.com.
Thanks, Ben. And I think probably I should disclose that I used to sing at Little Sisters for the Poor.
You did?
Yeah.
Interesting.
Well, I was part of a singing group, and we went to lots of places, and especially old folks' homes, retirement homes, and we would sing for them.
Okay, that's
Oh,
it.
wow.
I'm sorry.
That's fascinating.
Ben has George Washington on his wall. Or was it
No,
Jefferson?
that's not George Washington. That's my first cousin, 8 times removed, Thomas Jefferson.
There
Yeah.
you go.
His
Hey,
Aunt Mary
Ben.
was my direct ancestor.
Ben, I sent you a text. Send me your, there it is. I got it, Bandy. Okay.
There it
I'm
is.
gonna
It's in the
put your-
chat.
I'm going to put your email address in my report to the group so that they can get in touch with you.
So
Oh, well, thank you
Rebecca,
very much.
I'm going to thank you personally. I'm going to turn you over to Mandy, who will thank you on behalf of the organization. This has been great, and it's been good getting to know you.
Oh, great. Well, thank you so much for having me, guys.
I asked Mandy to unmute. There she is. And there she
Yes.
is.
Yes, thank you so much for coming and speaking to us. It was definitely informative on a lot of different issues that I'm sure many of us have heard a little bit about, but great refresher for anyone who has delved into it a little more too. And thank you again for all the work that you do.
And thank you for increasing our attendance to we about tripled our attendance, and it's because of you. And I think the messages you sent out, and I think that's going to be very good for us.
What was the total attendance, Peter?
The highest point was 36, and I think we averaged through most of the event 33.
All right.
Excellent. And yes, thank you all for coming and being with us here tonight.
Good night, everyone.
A lot of different organizations were represented here, Rebecca. So even though it's only 30-something people, it probably represents a lot of different groups.
Oh, well,
Yeah.
I think for a Zoom presentation like this is fantastic to get this many people.
Good, good. I'm glad we
Rebecca,
could do it.
can I ask a quick question? My
Sure.
husband was asking if you ever met Ron Reagan.
I have, yes.
Oh,
It was fascinating because my first convention with Freedom from Religion Foundation was in Seattle, and he spoke, and it was really funny because when I grew up in the 80s, and personally, my dad is very Democrat, and to the point that he hates Reagan so much, President Reagan so much that when President Reagan got his official stamp from the U.S. Postal Service, one day my dad went in and got these, like, to get stamps, and these were the only ones that were available, and he was like, you've got to be kidding me, I have to buy these. And then, so as like an act of defiance, he put them upside down on all of his bills that he was sending in. So I was really excited to call him and say, hey, I met Ron Reagan Jr. And he's a really fascinating guy. He has a fascinating story. If you guys haven't ever heard him tell the story about how he became non-religious, how he interacted with his father about that, it's amazing. He's a great guy.
So is there like a YouTube video of that somewhere or something like that? I mean, how would we get hold of that?
I bet it is on our YouTube channel. I will look it up and see. I mean, some of our speakers will have like writers that we can't tape or purpose their speeches, but I'll check and see. It's got to be around somewhere, I bet. If it's not a video, I bet there is some sort of print publication about it.
Right.
Yeah, let me know about it and I'll post it in our report.
If your dad ever gets to Cincinnati, he can try driving upside down on our Ronald Reagan Expressway.
I'm sure that would be.
Okay.
Thanks again, Rebecca.
Yeah, thank you guys so much. It was great meeting all of you.
Okay.
Thank
I'm gonna
you.
end
Thank you,
recording.
Rebecca.
Goodbye. Bye-bye.
Bye.
Thank you.
Bye, everybody.
Bye-bye.